Hello. In this recording of our Justia webinar, Generative AI in Patent Drafting and Prosecution, Bao Tran offers a balanced view of AI's potential in law, provides an overview of AI tools, particularly those that apply to patent law, and emphasizes the importance of understanding and adhering to ethical guidelines when incorporating AI into legal work. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Good morning, everybody. My name is Bao Tran, and thank you so much, Nina, for the kind introduction. Before we get started, I like to provide a little background on my experience and why it's relevant. About 28 years ago, I was with Fish and Richardson, and one of my clients was a startup, Align Technology, and they had this cute technology to move your teeth using computer fabricated dental appliances. And so that sounded interesting. So the company ultimately raised a Series A funding from Kleiner Perkins, and then they asked me to join them to help them as a startup. And at the time, all my colleagues were jumping to .com. This is, I think, around 1999 timeframe. Of course, not knowing any better, I jumped to a dental device company, and everybody initially laughed at me, but in the end, after the .com crash, I guess I had the last laugh. So Align went public, and the rest of it is history. So we had like in doing work from both as outside counsel and as from an in-house perspective, I've gained quite a number of interesting experience along the way. So anyway. After Align, I helped a lot of startup companies, and the need to become efficient was paramount, because startups really don't have much. You really can't spend a huge amount of time on them. You have to be very efficient with the work product, and so that's where I think my interest over time evolve over into how we can make our workflow more efficient, and that's when I started the Power Patent software process. The software is not meant to replace lawyers, but to be an augment to our workflow. So with that background, I'm going to go into the next slide. So with that background, I can tell you a little bit about how AI is going to be changing our practice. First of all, AI will impact in the drafting side of it. And it's going to make our workflow more efficient, reducing it from an average of, let's say, 20 hours per patent application, and trimming it down to perhaps 5 to 10 hours. So that's in the drafting side. And in the respond to the office action, it's also going to help in reducing the time to deal with the main independent claim. And because AI can easily apply the same methodology to the dependent claim, we can come up with a much more robust response to the examiner. And in my experience, when you present them with a full discussion of each claim as though you were pushing back on the independent claim, they tend to be more in the mindset of, okay, how can we work with you in moving this case forward? And so as a result of that, we beginning to find increasing adoption among the law firms, and as well as the corporation, the in-house lawyers in the corporation. And certainly we've seen significant venture investment in the tool. All you have to do is go to Y Combinator, and you're going to find that they've funded at least 2 or 3 different companies in the space. So that's the background environment we're in. So what are the key benefits of using AI, and what's the potential? More importantly, what's the downside, right? So the first thing we see is that it's substantial time saving. in both the drafting and also in the office action responses. We see that they're going to have better response because now it'll give you more time to go into each dependent claim and arguing them as though they're spending as much time on them as though you're doing the independent claims. And sometimes these AI will give you different views on how you can push back on a rejection, because they draw from a different set of perspectives than if you were just a human looking at, okay, here's the reference, here are the sections that the examiner relied on. The AI can actually look at the totality of the reference and argue as to why the combination wouldn't operate. So AI has also been used for prior art, and there are a number of solutions that would provide you with very good natural language search capabilities as well as image search capability. And so the result of all of this is that you have not only a more comprehensive patent application, but also you have an entire, cradle to grave support of the drafting, the prosecution, and also in the resulting licensing. And so the software some of the software tools will look up potential licensing candidate for you at the tail end. And so I think there's significant support for patent lawyers in helping the clients from protecting the invention, from getting the patent, as well as licensing and monetizing the patent portfolio. So some of the tools we've seen use certainly is, if we look at this corner right here, the patent classification end of it, we've seen the AI helpful in terms of looking at the claims as well as the language, and it would help then focus you to modify your language so that it's going to get into a particular art unit that's suitable for you. AI also has been used in evidence of use collection. So basically for claim infringement analysis and claim charting analysis that I mentioned earlier. So the AI is also used in invention disclosure. So we find that the universities and many research organizations, they have PDFs. The inventors would publish as a PDF into a technical journal, such as, let's say, the IEEE. The AI can take that invention disclosure and then directly convert the first draft for you. And you can use that draft to file either as a provisional application if you don't have the time to work on the case, and you just simply use the output from the paper and augment the application and the paper, and you file that as a provisional. And so the result of that is you're going to have a well-formed patent application with full support from the PDF disclosure if needed. And of course, we mentioned AI has been used in searching as well as also in validity of patents as well. So you got the yin and the yang of it. The AI can be used in the patent drafting as well as in also for litigation purposes, a detailed prior art search. And it's a full circle there, right? So that's the two AI tool available for the patent lifecycle. So let's do a quick comparison of AI tools versus the traditional methods. So in an AI, in a traditional approach, what we do is we craft the claims first, and then we get the drawings, and then we annotate the drawings with the reference numerals. And then you write the drawings sequentially. And in a long application, you can potential typos and errors can prop up. So, for example, you may you may cite to the incorrect reference number, And sometimes you may not use words that are identically match between the claims and the description. So those are just just inherently when you write a long document, is potentially prone to those mistakes. The AI tools, on the other hand, they can enforce computer methodology so that your application is precise, and you can have a more comprehensive approach. And what do I mean by that? Um, so when you write an application, you have certain terminologies that you may need to have, let's say, definitions. Let's say you may have uh, a particular uh, a word that could be defined, and it can the computer can automatically generate that for the definitions for you. The computer can automatically expand the drawings, and it can also, when it describes the drawing, because it's drawing from a bigger database of information, it can be provide a more comprehensive review, I'm sorry, a more comprehensive discussion of the drawing. Now, combine that with a human review and edit, that results in an improved work product. So to me, the AI tools can be used. It's not meant to replace the lawyers, but it's really an augmentation for the lawyers to write faster. So patents, the leading patent tools will all enable you to draft a first draft very quickly with minimum input. Most of them will be able to take a claim and then generate the patent applications from them. You can adjust the claims, and then it'll refine the text according to the claim. Then, some tools will allow you to take in the drawings and then expand and elaborate on the drawings, like the way a person would write. Other tools will also enable you to generate flowcharts automatically, but I have not found any tool that can take the drawings and automatically generate the drawings from the claim. So that's something that's still an evolving tool. That's something I think in the future that would be nice to have. So the AI tool, when you write the claim, they can also do a search, and that search can then be used as feedback for you to improve the writing of the claims. And that's particularly a nice ability. We are also seeing a trend where the AI tools, in addition to doing the prior art search, they would also look for prospective licensees. So that way, when you write your claims, you can also have both the validity side of it and also the licensing side of it. And what are the best practices for using AI tool? So we recommend that you use AI as an assistant. We definitely do not want, you shouldn't let it lose to write the application without a human review, because it's simply not a replacement. It can augment your knowledge base. You can write it and you can ask it to describe something in more details, and then you can edit it and control it. But definitely do not let it run on its own. The AI, some of these AI tools also allow the inventors to be involved in the process through a collaborative, where the inventors can go in and review the applications and then change it, and then you as the lawyer and the inventors can collaborate on writing the application. And version control is certainly a very good way of seeing who contributed to what. So in an AI based system, what you have is potentially the usual hallucination and also confidentiality issues, right? But on top of that, for patent generation, you have to deal with also inventorship issue, whether or not the AI is a co-inventor. And so let me address the confidentiality issue first. So most solutions these days they use OpenAI, the GPT, as the back-end engine, and so GPT, um, when you use it as a free version, they will definitely, that information could be used for training purposes. But when you use the version with an application program interface, i.e., a paid version, the information you have, under contract, OpenAI will not utilize that information for their own training purposes. So there's no confidentiality issue there. Many lawyers have looked at this, and I think that the conclusion is with the API that addresses the confidentiality issue. Number one. Number two is part of the advantage of using AI is that you will file the application very quickly. And so if you do that, your patent application has an earlier priority date anyway. So there's no, and to the extent, let's say if AI leaks this information, if any, right? Then from an inventor's perspective, they can catch that, and the infringement base is increased because now you are patent pending. So to me, those are the two ways of solving the confidentiality issue. Is first is under contract with OpenAI or any other LLM companies that you have that the data will not be used. And secondly, because your speed of drafting application is so much increased, there will be less of a risk of that coming back to haunt the applicant. So let's discuss the inventorship issue. The AI, I think under all jurisdictions, a human has to be an inventor. I think the only exception is South Africa. But even there, I think that it's safer not to utilize the AI as the inventive entity. So how do we control inventorship? We control that by using the claims, because inventorship is based on the claims. So if the humans write the claim and the system simply explain and describe the invention based, number one, on the claim and based on the drawings, that's a very tight way of controlling the inventorship issue, because you've limited the machine to writing things that were created by the inventor. And then, of course, the editing, the post-editing phase is another way that you can go to check on the inventorship issue. So I think that between the fact that the humans wrote the humans writing the claim and the drawings and the editing, you really view the AI as really your assistant, your co-pilot, and that minimizes the inventorship issue. So this slide discusses the confidentiality issue. If we use a system that is contractually obligated not to use your data for future training, that is a way to increase your confidentiality, and we've talked a lot of that in there. Another safe way to use the AI is to use that in in addressing patent examination. So that the use of AI in traversing a rejection is very similar to the way the AI is used for searching patents for prior art. In both of those cases, you do not have a problem with confidentiality, because it's all based on publicly available information. So this slide again is basically about using a vendor with clear privacy and data retention policies. You should periodically review the practices for AI usage. There is also a need to track as far as inventorship. So the solution you use should provide a paper trail for who contributed to certain aspects of patent drafting. And so that's so the system that you use should provide detailed records of inventor communications, their specific editing of the application, and also it should track, what part of the application was machine-based and what part of it was coming from the inventor. So this is a paper trail that would be useful for software in AI drafting. So with respect to the client communication, we believe that you need to tell the client that you're using AI. And so as part of the communication, you should explain the benefits, which is cost saving and speed, and the risk, which is basically potentially the exposing your information to the potential. You address the confidentiality aspect with the API agreements with the LLM vendor, right? And so you're balancing the cost savings versus the risk of using AI, and you should get client consent for AI usage. And update the clients on advancements in the tools. So in conclusion, we believe that 2025 will be the year for AI tool adoption. We've already seen a large firm going on the record indicating that they're going to be using AI in the patent prosecution and drafting side of it. So you need to observe certain ethical considerations, i.e. communications with the client, be aware of the confidentiality and checking for ensuring that the model usage is correct. However, I think many of these confidentiality concerns, the concerns, and let's say, and the fear of bias in the system and the fear of hallucination, they will pass over time. And long term, we believe that AI tools represent a paradigm shift in the patent practice. And for law firms, early adoptions provides competitive advantages as well as continuous learning and in the way. So with that in mind, I will transition before I transition to a demo of an existing software and how this is done. Is there any questions in the audience that I need to? Is there any question, Nina, or anything that I should answer before I transition to a demo? No open question.
I don't see any open, so feel free to go ahead and transition. Thanks, Bao.
Sure. All right. Let's see if I can share my screen, and let's say, okay. So, let's go to a typical app in AI patenting. So this particular application is Power Patent. And we will show you how to prepare a patent application from scratch, how easy it is. So let's go to the prepare application. So in this particular case, the app has 5 different ways you can provide information to it. You can start with the claims and upload the drawings. You can start with an invention disclosure. So let me go back. You can start with an invention disclosure. And so by that, what I mean is you can, let's say for a university, you can take a publication and upload it. And it will generate a first draft for you to review. You can do a conventional drafting where you can go through, let's say, enter in your usual name and then, ask it to generate a background for the invention. And then you can upload your drawings and then ask it to generate text from the drawing for you. You can also import a Word application. And this, I find it to be useful. Let's say if you have a template, let's say you have a computer, a mobile app application where you have generic figure 1 is a smartphone. You can import that template using this, and then it will generate the rest of the application from that template. And of course, you can also import from Google Doc. So let's start with the claims first. So in a claim, what I will do is I'm just going to take a claim from a patent application. Let's say 8 million. We're just going to clone in the claims of 8 million patent, and we're also going to borrow the drawings from that. So I will show you how we do that. Okay. All right. So in the 8 million patent, they have a set of claims. So let's say they have 12 claims. So what we do is we copy in the claim set from that issue patent. That's all you really need to do is paste in the claim. Then it can generate the application straight from the claim, or you can add images to it. And so what we'll do is I will show you how we can upload a set of drawings. Okay. And I'm just going to upload a patent with all the drawings, and I'm just going to remove them. So here we see that. So basically what we have now is a set of drawings. And you can see that, right? And that's all you really need. It will automatically generate the part description for you. If you have some inventor notes, the way I normally do it is I'll have the drawings, and then I'll ask the inventor to, okay, please go through this, this figure and describe why it's significant. And we can just go through all of that. And we record that, and we'll put it into here. And the advantage of doing that is that now the inventor will describe the part list for you, right? The reference numeral. But in this case, let's just go without it. All you do is you click on the draft application, and you'll see that right now it's 11:33, right? It should be done by in about 3 to 4 minutes, and you'll see that it will generate a very detailed description by expanding on the claims and by expanding on the description of the drawings. And they'll track, the correspondence to the drawing, so where that source of description is coming from. So you can see that in this case, the computer didn't just randomly on its own invent this. This is a human generated invention with specific drawing and specific claim, and all the computer is doing is just describe the invention. So now you're seeing that it's generating. So while it's doing that, let me describe another feature that we'll show you downstream. We've tried the response to the office action, and the way we've used this tool to respond to office action is the tool will automatically download the XML files of the office action as well as the prior claims, and also the prior arts that's being used. And then what it does is it'll respond to each rejection, and in particular, it will reference the MPEP in the response, so that it'll tell the reader, the source of the reason why we're traversing the rejections, and then also the MPEP section that support that. And we'll show that to you very shortly, as soon as this thing is done processing. It's taking, it's now about 2 minutes. So give it another minute or so, and you'll see that it's working, the work product. Let's see. And meanwhile, if anybody has any questions, please let me know, Nina, and then I can answer that as well. So when it finishes, you'll see that it'll transition to a screen where it'll show you all the different parts of the application. There it is. It's done. So we started at 11:33, and now it's 11:36. So you'll see that from the claim, it automatically picks the title for you. It puts in a very short background. It'll summarize the claim into the summary of the invention. If you want, you can also ask it to generate additional advantages for you. And then the abstract is basically taking the first paragraph of the summary and restate it as the abstract. So let's go to the description. So here, what we have is it auto-detected from the drawing. 5 is a strap, but if you don't like that, you can edit that. All right. 1 is an unknown part, so that happens to be I guess part of the glass frame. So it could be 1. So you can edit the diagram. So this is let's say frame. I'm going to call that. And 5 is, it's labeling that as, but I would call that as a eyeglasses. So you can edit that. So wearing a pair of AR glasses. So you can edit that, okay? And you repeat this process, but here you can, since it couldn't identify this, the way you would help it identify is by pasting in the inventor interview. And we could have done that, but we didn't do that in this case. So, and since this particular drawing didn't have any text, it couldn't figure out which part it is. So you're going to have to enter in, you're going to have to, you have to manually enter in. Let's see what this guy is. It also couldn't detect these particular, what label parts are. But once you identify the label into here, then it will, you can ask it to generate text, basically. So, oops. So this particular, you will see in here that the software starts describing the figures in here. And it's a fairly lengthy description. My guess is going to be around 20 pages of that. So you can edit with this, and it will also give you the part list, and you'll notice here that it's automatically identifying the parts for you. In this particular, it basically, this is telling you that we need to go back and edit the brief description, but for now, for just demo, we'll just skip that. So you can go into here and you can describe, you can select your boilerplate in different sections if you want, or you can use your own boilerplate here. The claims, you can, so here's the claims that you entered, and it automatically generated a sketch of the claim for you. And you can, if you want to change the position, you can just drag and drop it. You can also do a search in this particular. So what it's doing here is it's mapping the claim language into the prior art. And so since we copy these claims from an issue patent, it basically detected that right here, the visual prosthesis, and it's right now doing the mapping. So if you'll give it a little while, you're going to see that it start mapping out the where the claim is. Yeah, there it is. So it'll bring back the prior art, and it'll attempt to find out where your language is mapped into the prior art. And so you can review the prior art and then amend and change your claim if you want. And so they are doing a version of this now for trying to see how your claim would potentially be used in a commercial side, i.e. potentially the claim coverage side of it for monetization side. So that's a little bit of the demo on claim editing. Here's a diagnostic. And so what it does is it'll identify occurrences of text in potentially it's being confused. So here, somehow we have a text that says a reference sign 10. And the other term is laptop 10. So it identified that there are potential inconsistencies between 10 and laptop or reference signs. And so here also it's identifying where the term is used, right, in the description. And this is also good for means plus function analysis. So for example, if you say if the application references a means of communication, it'll tell you, okay, where is what is mentioned in here. So that's the diagnostic part of it. You can also get a PDF of that reports the it reports your usage. So you'll see it here. Your claim, your antecedent basis issues, if any, and your support. So in this case, there's no error. And you can export it as a Word document as well. So now you're going to see what the patent application looks like. And so many people prefer the document straight as a Word document. So now you'll see it. And let's scroll through that. So this is just from the claims and from the figures. You're going to see that it's generating approximately 25 pages of text with the figures in there for you. So a fairly rapid way of dealing with drafting creating your first draft. From what I've seen, it will generate, I think, in about 10, about 5 to 10 minutes. It'll generate the first draft, and then I'm going to spend 2 or 3 hours editing it. And it would be a work product that you can send out for client review. So that's my experience with that. So let's go back to, so that basically concludes the drafting side of it. Let's go to the docketing side of it. So what we do here is in the docketing side, we have a way of communicating with the patent office, the patent center, and download that information into here. So it's kind of like a very simple docket function, but its real power is in the fact that it can actually download it can download an office action, right? And so and respond to that. So as an example here, so when it downloads an office action, you can ask it to generate a response live, or the way I run it is I typically let it run overnight, and then it will generate all the responses already. And then now I can just pick it up and ask it to and review the potential response for it. Right. So here it summarizes the rejection, and then here it starts to respond to the 103, 101 and 103 rejection. Let me see. Yeah, here it's responding to the 101 rejection right here. And it does this by, based on the PTO guidance, right? And then you'll start seeing also it's responding to the 103 rejection. Here it is. It starts here. So, and the way it does that is it downloads a reference, each reference, and then it'll attempt to analyze the reference and argue as to why the combination would be inoperative. And so the machine, comes up with sometimes a reason that is actually better than a human. But I think the way I use it is a collaboration. I look at how the office action, what if, its reason for why the combination wouldn't work, and then I come up with my own independent reason on why the combination would be inoperative. So I do that for the independent claim, but for the dependent claim, I more or less use the output that it generate, because I just don't have time to go down into the details of each and every dependent claims. So and you can see that it's doing this for every claim, and that's something that I will have time to go and drill down on in detail for each claim. So so the way I use that is to use that as an argument, and then I'll look at it to see if the reason is correct, then I use it, and if the reason is weak, then I use my own reason. But it can, using this tool, I can do an office action response also in about 2 to 3 hours, because I can just review its work, and if I think I need to supplement it, then I'll do so. But in general, it has a very reasonable argument as to why a combination wouldn't work. So that's basically an overview of the office action response. I think we're running up close to time. So Nina, you're showing up. So are there questions or things like that I need to answer?
Yeah, so we have a couple questions about the actual tool. So let's see. The first one here is, are there any available official actions yet that reject claims based in invention by AI?
Well, I think there was one case. I forgot the name, but there was is it Australian inventor, where they they applied in numerous jurisdictions. In Europe they got rejected, in the US they got rejected, and in South Africa I think they got it granted in South Africa, either South Africa or Australia, but only one country in the world um, approved a patent that was invented by AI. So in that case, the AI was generating various shapes that has particularly advantageous functions. And so because the AI created those shapes, they decided to apply for the application using the AI as an inventor. And the name of that case escaped me, but that case ultimately went through Europe and the US, and both jurisdictions rejected that as not human originated inventions.
Awesome. Thank you for that insight. Our next question is about the tool itself. So, are you uploading JPEG or JPG files, or are they actually drawing files from Visio or something similar?
Uh, that particular tool, Power Patent, can take anything, JPEG, PowerPoint, Word. Basically, what it does is it takes all those files and convert them into ultimately the JPEG image, and then it works from there. So they can take a number of formats and convert them into a common format for it to work on.
Okay, great. That's great to know. And then this person also said, when you were going through the different figures, it said they were still labeled inside the figure file with the original 8 million patent number. So it had the original patent number. If you're using this example to create a new application, like if it was a brand new application, would it still keep that patent number, or would it be brand new?
I'm sorry. There was another phone on my computer, and could you repeat the question again?
No, that's okay. So they were just asking about some of the figures that were inside the figure file. They had the original patent number that they were associated with. If you're using this tool, Power Patent, to start a new application, would it still pull over that patent number?
Oh, I use that just for demo.
Okay.
In a real patent application, you of course, you wouldn't be using a patent drawing, an issue patent drawing as your input. So I use that just for pure expediency. But in a real application, you would create your own app drawing either by hand or using a professional draftsman, and then you would upload those drawing either as a PDF file or image file individually, or a PowerPoint, and it would automatically take that. So you wouldn't see those drawings in a normal application. That was just for example. So sorry about that.
No, that's okay. Thanks for clarifying. And then this person just asked a follow-up question. it says, but you can use an issued or at least pending patent whenever you're doing a CIP or continuation. Okay.
Yes. Well, if you have a continuation already, then you have the original drawing. I would use those drawing, and we are working. I've requested that the feature be allowed so that you can crop out the image, but that's something that's probably early next year that you're going to see. But so you can crop basically. And that's the way you would handle also multiple images in a single page as well.
Understood. Thank you. All right. And then it looks like I'm just going to open it up to more general questions now that we're kind of done looking at the tool together. So if anyone has any more general questions, then please feel free to submit them. You can click on the Q&A button in the control panel at the bottom of your screen. Looks like we've already got a couple coming in. So this next question is about billable hours. So please explain the benefit. Oh, sorry, it jumped. Please explain the benefit to the patent attorney when you're billing a client for less hours, and so like 10 hours instead of 20 hours. How do you navigate that? What does that look like for you in your practice?
Well, I think for those lucky one that can bill by the hour, this tool, I think you have to explain it differently. For many of us, where we are on fixed fee, so for example, with a company, you might be committing to, let's say, $7,000 to $8,000. The use of this tool is particularly advantageous because, well, the fixed fee rewards efficiency, right? Now, I think for the majority of patent prosecutor, we're on fixed fee. For the lucky few who are on hourly fee arrangement, the way I view this tool is that the tool is not meant to replace it. The way you use it is meant to give you more a different perspective on how it'll give you more time to talk to your inventors and explore, okay, what other alternative possible use of this invention could you contemplate? So it gives you time to spend with the client and to show your added value, and yet keep your bill in a reasonable range. So one of the things that we talked about is, generally most inventors think about what they've they invented just right in their specific context, but we as lawyers rarely have the time to push them to the next level to say, well, what other application could you see this technology be applicable in, and how would you modify it to take care of that application? What other industry could it be used in? And so if we spend more of that time exploring those avenues and use the AI as a co-pilot to amplify your thought, saying, well, this invention could be used in, let's say, in the medical industry, in the robotic industry, in rockets and things like that. So I think that it's a way of increasing your value to the client. It's not meant to cut your bill. I don't see that. It's the same argument as though when the spreadsheet came out, did it reduce the accountant's fee? We see that they thrive on that because now they build on top of that and add value. In the end, the value to the client is what's important.
Thank you for that insight, Bao. Our next question is the information in the generative AI tool, like Power Patents database, even if it's confidential, is it discoverable?
We give you a button where you can delete the file at the end, because obviously um the computer has to have some inkling of what your invention is in order for it to work on it. So there is as you saw at the end when I exported the Word document, it asks you whether or not you want to delete the file. You always have the option to come in and remove the file and it'll be gone.
Awesome. Our next question is, how adaptable do you feel these AI tools are for small and mid-sized firms versus very large legal departments?
I think it's very adaptable. To be honest, it's scalable. In various uses. We've seen it used inside of companies in a small a startup with a single lawyer, where they use that as an invention capture tool, where the inventors provide the information, the lawyers would take that and very quickly spin it into a non-provisional type of application, but they file it as a provisional. And then at the end of the 1 year, they send it out to the outside counsel to say, hey, this thing is already kind of in, 60-70% of the shape, and we want a discount. We want you to give us, we'll give you more work, but basically, give us some benefit for that, the document that's already in a non-provisional format. In the big firms, the advantage is now you can look at other similar patent applications done by the firm, and then it can borrow language from there. So there are there are advantages to using templates from done by other lawyers that you can then bring into your case and then write on top of that. So in many cases where, let's say, you got a continuation or a continuation in part patent application, you can pull that application and then add your enhancement on top of that. But I think fundamentally it works well for it's scalable, i.e.
Awesome. Thank you. Our next question is, can AI be leveraged to predict patent approval probabilities based on historical data? If so, how have you found if they're reliable?
The probability of success. Personally, I don't. I guess I haven't looked at that angle. But I think I haven't applied. I haven't seen AI dealing with that. But from my personal experience, we know that in continuation cases, we work with a particular examiner, and they're very predictable. They have a particular angle that they're looking for, and you can tweak your claims toward that examiner's preference. So I think that's something that it's still very much a human thing that the machine cannot predict yet. That examiner, his or her behavior, and so you can add a minor tweak to that. So as an example, earlier in this week we had an office action, and the software generated a 50-page response, which we sent to the examiner as a locked PDF, meaning that the examiner cannot take that and put it into the file history. So that's a password protected PDF. He can view it, but he cannot put it into the file history. So but when we had an interview with the examiner, you can hear that the examiner is saying, well, yeah, but I can see your argument, but your claim, if you were to modify it slightly to do this, it would definitely overcome my art. And so, of course, that's something a machine won't be able to pick up. So we plug in those two words and submitted the response and deleted all of the 50 pages of argument, because now we've showed the examiner that, look, we can certainly provide a very detailed, in-depth argument as to non-obviousness, but by doing that, it's going to put a lot of history in the file, which the litigators could use that to their advantage. And so what we do is we send them a PDF that's password protected, so that it won't be entered into the file, and then we discuss with the examiner, and then we can then tweak it to what we think is the examiner's easiest path to allowance, if that makes sense.
Yeah, thank you for that additional insight. We also have a couple questions about power patent pricing. Do you know where someone could go to find that additional information, or where you can direct them?
Yes, you could just go to powerpatent.com. There's a page, but the price is $4.99 per month, and so which I think is fairly it's the price is pretty reasonable for if you do just an office an application. That price alone is well worth it.
Awesome. Thanks for that. And then we have another question here. Can generative AI handle the complexity and specificity required as patents can be very technical? Have you found that these tools do a good job of addressing that?
Yes, and I find that sometimes it actually, it knows more than I know about a particular field. I do a lot of 5G and software patent applications. The advantage of the AI is that it has the entire internet access at its path, right? And so if you guide it correctly, if you put the proper um, guardrails around it, it's going to be very, very good. Just think of it this way: if you were a new patent attorney and somebody threw you a topic that you're not familiar with, guess what? Whatever you write, you are in a way, quote unquote, hallucinating because you're not familiar with it. So the AI hallucination aspect comes in because the AI doesn't have enough information, so it starts to make things up. And I think humans do exactly that, right? So the way you control all of this is giving it very specific guide rail as to what it should be working on. And so the way we give it a very strong guide rail is based on, number one, the claims, and number two, the drawings. As you notice in the application, each drawing has a bunch of reference numerals in there, reference signs, we call it. And when you give the label and the noun associated with that label, you're basically giving it a guide rail. So in a drawing, let's say if you have 20 of these numbers in there that describes the components within the drawing, when you're giving it that kind of a detailed specificity, it's going to be very good, and it's going to focus on what needs to be done. And so I've seen cases where a new attorney who's not familiar with a particular technology, using this tool actually was very efficient because the AI put in an initial draft that was reasonable enough so that that attorney, even though he was not familiar in that particular space, can start from there and then add to it, and it helps the people who don't have quite the specific technology to get started quicker and easier, because now you got a starting point. And I've heard that repeatedly, because a lot of people, the users, they'll say, oh, you know what, it's hard to get started writing something, and this thing now places a document right in front of you. You may hate it and you can completely slash it out and rewrite it in scratch, but at least you got a starting point.
Great.
But in general, I find that the text generator is quite useful. And so that's why, on average, we spend about 3 to 4 hours cleaning it up after they generate the draft. And that saves us still a substantial amount of time.
That's great. Yeah, kind of building off what you were talking about with drafting and editing. Once you're done with the draft, the initial draft that it gives you, this person asked, how can I effectively audit and validate the accuracy of what it's generated with regard to patent claims or descriptions? Can you talk a little about your process with that?
So you're talking about the claim, in, I guess, in the example that I provided, the lawyers generated the claim. So most lawyers prefer to control it by generating the claim. So the claim is the input. So now the validation aspect is there is a search button, and we don't call it a prior art search, because just we're just kind of leery of saying, well, this is a prior art search. It has connotations with that. So we just say it's a similarity search. So, but that search does go into the patent database and bring up similar references that you can take a look at, and then you can, if you think it's indeed a prior art, then you need to submit that in an IDS form. But then you can navigate your claims to account for that prior art that you encounter. Now, in corporations, most corporations they prefer not to do the search for various reasons, right? So so you can disable that search feature, or don't use it. So that's one way, is you can fine tune the claim based on the search. As far as the support in the description, support for the claim, we do have an entire set of diagnostic that indicates whether or not your claim text is supported in the description. So if you see the and this is a real-time feature, so you'll see it appearing in the claim. It'll start color coded, or it'll say, you look at it and you say, okay, this phrase doesn't occur anywhere in the description. You can then copy that phrase and then go into the description and then insert. And you can even ask the AI to create a text description for the phrase that it highlighted as not, being present in the claim. So it's a very easy way to fix the claim support, the 112 claim support features. We also have the whole diagnostic, as you've seen, as a PDF. So I think those features are going to help you in terms of crafting the a 112 supported application.
Awesome. Well, thank you so much, Bao, for that additional insight and answering all of those questions, as well as showing us that lovely demo. And thank you all so much for your questions. We want to thank you so much for joining us for another Justia webinar. Again, as I mentioned at the top of today's presentation, for all the lawyers in attendance today, I wanted to remind you of the benefits of joining Justia Connect Pro. It's available for any lawyer with a claimed profile in our directory, and you can upgrade your membership to access benefits like our AI-powered Justia chat to open up a whole new avenue of leads. You can also, as I mentioned, get credit, CLE credit, for attending live and on-demand webinars. You'll also receive an enhanced profile in our Justia Lawyer directory and access to our Justia Connect Pro $200 credit to save on select marketing solutions. So if anything sounds great to you there, you can go to pro.justia.com to learn more, and have a wonderful rest of your day. Thanks for joining us. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.